Hi everyone. This video is a bit longer because we're diving deep into the critical topic of attorney-client privilege in estate planning. But if you're short on time, here's the upshot. Attorney-client privilege protects your confidential conversations with your lawyer, but having a third party, like an adult child, present can waive that protection. This can lead to sensitive information being exposed in future disputes. Watch this video to learn why privilege matters, how it's waived, and how to involve family without risking confidentiality and attorney-client privilege. In estate planning, confidentiality and attorney-client privilege are foundational principles that protect clients' rights. They ensure open, honest communication between clients and attorneys, which is critical when making sensitive decisions about finances, healthcare, and family dynamics. The attorney-client privilege shields communications between a lawyer and a client made in confidence and for the purposes of obtaining legal advice. In Massachusetts, this privilege belongs to the client, not the attorney. Its purpose is to encourage clients to share all relevant information without fear of that information being exposed, which allows attorneys to provide accurate and comprehensive guidance to their clients. Privilege is crucial in estate planning for several reasons. First, it allows clients to discuss complex family dynamics and sensitive issues without fear of judgment or disclosure. Whether clients are grappling with estranged relationships, financial concerns, or personal insecurities, they have to feel safe sharing these details for their attorney to create an effective plan that takes all factors into account. However, this privilege can be inadvertently waived if a third party, such as an adult child, is present during the attorney-client discussion. The Massachusetts Rules of Professional Conduct, Rule 6, emphasizes that lawyers must preserve confidentiality of client information unless the client provides informed consent or the disclosure is otherwise authorized by law. Involving a third party without informed consent risks breaching this rule and nullifying the attorney-client privilege. Consider a common scenario. A parent invites an adult child to a consultation for moral support or assistance in understanding the legal process. While this may seem harmless, the child's presence effectively waives the privilege. The information discussed is no longer considered confidential, potentially exposing it to discovery in legal disputes in the future. The decision to involve a third party ultimately rests with the client. However, clients often dismiss concerns about privilege without understanding the potential consequences of waiving the privilege. Once the privilege is waived, sensitive information could be used in ways the client never intended, such as during family disputes or legal challenges to the estate plan in the future in the probate court. Take, for example, the case of In re Rice. This case highlights how attorney-client privilege could be impacted posthumously when the multiple parties claim an interest in the estate. In that case, it was a wrongful death action, and it was important to understand what was said to the attorneys prior to passing. The court scrutinized whether privilege could be maintained or waived by fiduciaries like a trustee or a personal representative. The outcome underscored the importance of clearly defining privilege boundaries during a client's lifetime, and ultimately, a special personal representative was appointed to waive privilege. Similarly, in Clare v. Clare, privilege disputes arose in the context of a family business. The court affirmed that privilege is narrowly construed and emphasized the risk of involving third parties in privileged communications. These cases serve as a cautionary tale for clients who underestimate the complexities of confidentiality and how important some information can be in the future. An attorney's role is to counsel clients on the implications of waiving privilege and to recommend alternatives. For instance, attorneys might suggest holding private consultations with the client first to establish baseline goals and concerns before bringing in family members. Clients should also be educated on documenting their decisions independently. This reduces the risk of undue influence claims, particularly when adult children are the beneficiaries or the executors of the estate. For example, if a parent modifies a will in the presence of one child but excludes others, the excluded children might later allege coercion or undue influence, especially if privilege was waived during the planning process. Now we can call in the attorney to be a witness at that trial. That can be a problem. When disputes arise, documentation of confidential communications can help uphold the integrity of the estate plan. Detailed meeting notes and side declarations affirming the client's autonomy can sometimes mitigate these legal challenges. Ultimately, confidentiality and privilege are about empowering clients to control their narrative and their own decisions. While family involvement can be valuable, clients must weigh the benefit against the risk. A strong estate plan prioritizes the client's wishes while carefully navigating the complexities of family dynamics and legal safeguards. Clients often want to tell their family about everything, but sometimes that's not in their best interest. By understanding the nuances of privilege and confidentiality, clients and attorneys can work together to protect the integrity of the planning process. These principles are not just legal formalities, they are the foundation of trust and effective advocacy in estate planning.